Good morning, everyone. I hope everyone is doing well. My name is John Elston, and on behalf of the UCI Black Alumni Chapter, I want to say thank you for joining us today. Today's webinar is called Health and Wellness, a Black Perspective, and the subject today specifically is caregiving and estate planning. For those of you that have attended one of our previous webinars, I say thank you and welcome back. We're very happy to have you, and we appreciate your continued support. For anyone that's new here or the first time, a little bit of context for you. Health and Wellness, a Black Perspective was created out of the longtime philosophy in our communities. Each generation is supposed to get better. This is webinar number 5. Previous topics have included COVID-19, educating our children, managing your mental health, and financial investing in home ownership. The link for all of those webinars are available, and if possible, we'll post them in the chat. If not, you can email the UC Black Alumni Chapter, and we will make sure we get them to you. The unique thing about these webinars is they're taught exclusively by UC Black alumni. These alumni are not only some of the best professionals that their field has to offer, but they volunteer their time, their talent via these webinars to help others. I am personally proud to be associated with this goldmine of talent, expertise, and knowledge. In other words, and I'm going to do the conversion that we use in the hood, this ain't Pookie and them, y'all. This is the real deal. These webinars are free, and they're open to students, alumni, friends, family, community members, and others. So please spread the word and encourage others to attend. The only thing I can tell you is about coming forward. Let's just say it keeps getting better. Today's topic, though, however, is again, health and wellness, a Black perspective, caregiving and estate planning. That's an important topic that none of us can ill afford to miss. Our esteemed speaker today, Caprice Collins, attorney at law, is like all of her predecessors who have participated in one of our webinars. She is awesome, and we're lucky to have her here. So I want to say thanks to Caprice for being here, and thanks again to everyone else for taking the time out of your Saturday to be here today. But before we begin, I need to say thanks to a few other people who have made this happen. The UC Irvine Alumni Association, also the UC Irvine Black Alumni Chapter Board, which, as we say, it represents everything from typewriters and peachy folders and 8-tracks for those of us that are a little older, to Google Docs, Stay Woke, and Instagram for those of us who are not a little older. Last but not least, I want to say thanks to the 2 talented women, and let me introduce them because they are really the people that make this happen, and I'm honored to work with them. The first lady represents UCI class of 1995 with a BA in political science and a master's in public administration. She is an associate director of facilities, and she will be giving you the logistics. Please welcome Ms. Arnesia Bryant. My second host, she represents UCI class of 2004 with a bachelor's in sociology, and she has an MBA. She is a marketing professional, and she is our host for the day. Please welcome Ms. Sandra Rosenfeld. Thank you, ladies.
Good morning. Today our webinar is on caring for those who care, caregiving and estate planning. And during this time, we have a few logistical items that we would like to cover with you as we go through or before we actually begin the presentation portion of the workshop. So first, we'd like to say that we have committed to giving out 3 gift cards to those who remain on the webinar until the end. So I will be going through and placing your name in a wheel that we will be utilizing at the end to award those 3 gift cards. For those who will become the winners, it will be important for you to give us your name and your email address. And we will do all of that. Again, I will repeat at the end of the webinar, just so you know. Next slide. The other logistical piece is we have a disclaimer. So the disclaimer is as follows. The information presented in today's event is provided for general information purposes only and does not constitute legal or other professional advice as any subject matter. University of California, Irvine, UCI Alumni Association, Black Alumni Chapter, and webinar panelists do not accept any responsibility for any loss which may arise from reliance on information presented in today's event. Some of the links shared may lead to websites operated and maintained by third parties. We are providing these links solely as a convenience, and the presence of such links do not imply any responsibility for the link site or an endorsement of the link site, its operator, or its contents. Next slide, please. Now I would like to turn it over to our talented moderator and host for today, Sandra Rosenfeld, who is what I call the Mastermind of Moderation. So Sandra, if you can just go ahead and take over. Thank you.
Thank you. And thank you again to everyone that is joining us today. As we all know, when it comes to this topic of caregiving and estate planning, for a lot of people, it may feel like it's very daunting. It may feel like such a big deal. For some of us, we think, hey, I don't have to worry about that. I'm young. That's not something to deal with. Or some of us may be in the thick of it, and we may feel like we don't know what to do. We don't know who to turn to and what I'm up against. Or you might just feel like you're alone and you have to figure it out alone. Well, I'm here, and along with everyone else here, we're here to tell you, you are not alone in this. And there are a lot of people who are dealing with this, and it is okay. And you will find a way to find the best path, routine, and process that will work best for you and your loved one, whether you're in the thick of it now or at some point in the future. And I do want to share this. I want to emphasize this, and I know that our guest speaker, Caprice, will emphasize this as well. You're never too young or too old to consider all of the things that come along with caregiving and estate planning. As some of us may be aware when looking at the stats that are currently on the screen, African Americans are often burdened by caregiving situations, more so than our counterparts. And when it comes to caregiving, given the recent, as we're dealing with it now, with the COVID-19 pandemic, many people had to step up and become caregivers. And this is especially on the rise for those that are younger in age. As you can see on the screen, 25% of caregivers are Gen Z, which represents those that are ages up to 24, millennials, which are ages 25 to 40, compared to Generation X and Boomers. So as you can see, when it comes to caregiving, those that represent those that are in these unpaid roles, taking care of loved ones, the numbers are rising. So it's becoming even more and more significant in terms of how many people are in this situation. So with that said, when it comes to those that identify as Black, on average, they are providing about 31 hours of care every week. And with those that are caregivers, that identify as caregivers, 58% are financially prepared to provide current or potentially provide caregiving duties, compared to 67% of overall caregivers. So meaning that Black caregivers are not as prepared. They're not as ready to be able to financially support or step up and be able to lend support and help to their loved ones. The reality is that when it comes to caregiving, it is disproportionately affecting Black women within the space. However, the reality is 15% of Black caregivers are men. And that's not a small number. As you can see on the screen, that percentage represents about 2.3 million African-American men. So when it comes to estate planning, it's important for everyone to come together and think about, what does that look like? What type of family planning, what type of wills or trusts that you want to put in place for your family. And it's best to start this conversation and start this process as young as possible, especially if you have children and you want to ensure that they're cared for and that they're set up with the support that they need as soon as possible. Because as we know, when it comes to life, when it comes to death, for many of us, that's not something that you can prepare. We don't know when that's going to happen. So if we can do a lot of planning in advance, we will be best supported and best set up in advance. And I wanted to share a key stat here that I read here from Forbes. Of those who do not have a will, 78% are millennials and 64% are Generation X. These are very high numbers. So it is very important that we keep this in mind as we are thinking about this whole process. And so lastly, before I hand this over to Caprice, I just wanted to share some tips about caregiving. As we were discussing this presentation, doing the research, I'm realizing that many people do feel like they're alone in this process. I just want to offer some tips. And there are a lot here listed, but more importantly, I think the number one tip that I do want to share with you is definitely seek out support, because the support systems that you have in place through your friendship networks, through your colleagues, through local organizations that are affiliated with a disease or illness that your loved one is experiencing will only help you be the best caregiver possible. So that way your loved one can have the best possible life and the best possible care. Because as we all know, you can't pour from an empty cup. So you need to find the different ways to pour into yourself before you can pour into others. So with that said, I'm going to turn it over to our wonderful guest speaker, Caprice L. Collins, Esquire, attorney from Collins Law Group. And we will have a link shared out in the chat with her wonderful bio. So you can see that she has been in the trenches. She has been in this field for decades. So she is very experienced on a professional and personal standpoint to provide this type of conversation and advice and resources here. So without further ado, I'm going to turn it over to Caprice.
Good morning, everybody. First of all, Sandra, will you be advancing the slides as we go along? All right, thank you. So our presentation today is called What Every Caregiver Needs to Know About Planning for Death and Incapacity. And that is generally the role or the time in which most people are acting as caregivers, is at a time of incapacity of a loved one. So can we have the next slide? So welcome, everybody. I probably I know I'm the most elder of all of the participants in terms of our panel and organizers today. I'm a proud graduate of the class of 1975. What they don't even have in existence anymore, which is comparative culture. So I was there when the first Black attendees of UCI were really starting to roll in, and definitely I think a recipient of the affirmative action programs that were popular back in the late 60s and early 70s, and really enjoyed when Irvine, when we could see the cows grazing on the hills of the Irvine Ranch at the time that I was there. So it was an early time to be in Irvine. Really enjoyed the experience. Very happy to be with you all today. I have been practicing law now for 41 years. I have chosen estate planning as my primary role as an attorney in my community. I've joined the most prestigious organization for estate planning attorneys in the United States, which is the American Academy of Estate Planning Attorneys. I was the first African-American member of that particular organization, a national organization which really seeks to have all of its members practice at the various high quality that we can possibly do in our particular communities, providing us with all kinds of continuing legal education, software and other types of education on a regular basis. And we just focus our practice on business estate planning, special needs planning, business formation, and trust administration. What I do pride myself is that we do provide educational experiences to the general public on a regular basis. And I'll talk a little bit more about that as we get closer to the end of the presentation. Now, I'm proud to say I'm a homegrown girl. I started my education in the Compton Unified School District back in the 60s, and then went on to LAUSD, graduated from Dorsey High School, went on to UCI, and then received my law degree at Harvard. And I'm very, very proud to say that our firm has represented thousands of African-American families and others here in the greater Los Angeles area, representing families, children, grandparents, and it's very rewarding to have a multi-generational group of clients who support each other in their planning. What we're really seeing today, and I really want to compliment the other organizers here that are in the roles of caregivers, is that we are seeing a lot of millennials and Gen Xers bringing their parents, those of us who are baby boomers and older, to us for estate planning. So what is great to see is that younger people are recognizing the importance of this, the importance of protecting their family members, obviously, but also the importance of making sure that Black generational wealth is passed down efficiently. Next slide. And in order to be the very best planner that I could be, I've actually acquired 3 other licenses. I'm a licensed insurance agent, financial advisor, and real estate broker. So what does that mean to my clients? It means that I have a lot of extra education and expertise to help them in the planning of those things that really are generally what comprises their estate. And happy to say that we've received much recognition from various organizations over the years. Now, I am very proud to say that I have authored a book called The Ultimate Caregiver Guide. And this is a how-to guide for caregiving, talking about everything from preparation to the types of care that might be available for your loved one, all the way to end-of-life care. And this book was inspired by my own caregiving experience. I cared for my loving mother, Yvonne Collins, for 10 years during her ages of 86 to 96. So I have personal experience with this. Any of you who would like a copy of my book, at the end of this presentation, you'll have all my contact information. Just send us an email and we will get it out to you as soon as possible. We're going to skip the next slide. I talked about it previously, and I just want to let you know that there is a dynamic team of individuals, professionals here in my firm to serve you and your family. We do have Spanish-speaking members of our team, so we can also assist that community. Now, the reasons for this program are many. I just attended a wonderful Alzheimer's of Los Angeles program yesterday, and they brought to many of those that were in attendance knowledge that I think Sandra kind of covered a little bit this morning, which is that this disease, Alzheimer's, really strikes our community at a greater rate than those of the majority community. We're 3 times more likely to develop Alzheimer's. If you're a woman age 60 or older, such as myself, we are 4 times more likely to get Alzheimer's than we are to get breast cancer. And most of the caregiving, as Sandra stated, falls on Black women in our community, even though I do find our males are is understanding of this responsibility when they need to be. So what we're going to talk about is, first of all, how to understand the situation that you might be placed in a little bit more from a legal perspective, how to be prepared to avoid unnecessary trauma problems that may come along from being unprepared, knowing the role that you might seek to act in, and how can we avoid costly mistakes in the process. First things I would say is that families are secretive. We find that A lot of times elders are secretive in terms of their own desires and assets, but we're finding that more of them are sharing and more of their younger family members are getting involved. But for those who want to get involved, we have to be informed. You have to be informed of these obligations and these roles that we're going to talk about today. What unfortunately we do find is a lot of family members are indifferent. They don't pay much attention to their elders on a regular basis. They ignore obvious signs of need for caregiving until a crisis erupts. And then they're unprepared, and often a lot of family drama ensues. So in my experience, both spouses of individuals who need care and other family members are very confused when someone becomes either needing of care or passes away. Generally, they're unprepared, they're disorganized in terms of the records and of the assets that might be owned and the desires of the individuals who they may be caring for. And when that person becomes incapacitated as a result of dementia, it can even be worse because many decisions that they themselves might have been able to make to the end of their lives no longer can be made. Worse yet is that our community is very underprepared for the cost of long-term care. And that's one of the reasons I think that unfortunately we as a community are more involved in caregiving, because our parents and ourselves, we don't plan for the expense of long-term care. Right now in Los Angeles County, it costs on average about $10,000 a month for long-term care, quality care. Many of our families want to stay home in their homes, and often that involves 24-hour care. So that can be even more expensive. And one of the reasons why women get so involved in this is because there isn't the resources to be able to pay for a full-time caregiver to come in. Usually that would be 3 individuals in one day. So family members have to pitch in order to be able to protect their family members. This is the best time, if you're in the ages of 40 to 60, to buy long-term care insurance. There are many options involved. I do have a financial group that if you're interested, we certainly can talk to you about that. But please understand that we can't wait till we have developed certain medical problems, particularly where signs of dementia are already present, to buy long-term care. You're uninsurable at that point in your life. So let's talk about the negative impact of not being ready for this. Well, obviously financial loss can occur just by having to pay for the long-term care and not having resources necessary to do that. There are a lot of unnecessary fees, costs, expenses that can be avoided. We also have sometimes the wrong people acting as caregivers in the family. And we see that quite often, which is very sad for us to see that, because often it involves elder abuse. Even if we're talking about both kinds of elder abuse, physical and financial, because the family isn't prepared, because people don't step up, because the wrong people step up. And then litigation also ensues. Right now, litigation in the area of estate planning, trust, probate is at an all-time high. And part of it is because of the wealth that's being transferred from older members of our community to younger members, and the fact that there was no preparation for that. Even if litigation doesn't occur, family disputes, drama can leave a family broken because these important issues weren't actually dealt with. So there are 3 life cycles that will render people unable to care for themselves. Obviously, death, when they're no longer here and present, incapacitation due to either mental or physical illness, or just medical decisions that must be made on a temporary basis if someone has a medical condition that precludes them from doing that. And the person who acts on behalf of that person during these periods of incapacitation is called a fiduciary. And so this is a person that you, if you were to provide, if you were to pick a fiduciary, you would be able to rely on at a time when you are unable to act up for yourself. So let's define what we're going to be talking about today so it's easier to understand as we go through these concepts. Number one, the elder will be someone that is the focus of planning. That could be your spouse if you're married, obviously it could be your parents, another family member, a friend. And that person under the law is considered the principal, the person who is actually in charge of their own affairs. A fiduciary relationship is founded on trust and confidence in a person, generally because of the integrity they've shown in their own life experiences and manner where how they've handled their own challenges and their own financial affairs. Being a fiduciary is a very, very high obligation in California. Can we go to the next slide? In fact, being a fiduciary in California is the highest fiduciary duty in the state of California, being a trustee, being a power of attorney agent. And the reasons for that are because you are, as a fiduciary, in complete control, have complete authority over someone's perhaps both medical and financial situation. What the law requires with this authority is a duty to act on behalf of that person, the principal's matters with such good faith, trust, honesty, and to not in any way be unfair or self-serving in the manner in which you handle their affairs. Next slide. So there are some big red no-nos as a fiduciary, things that you should not be doing as relates to your relationship with the principal or the elder that you're acting on their behalf. You cannot exert undue influence or pressure on a person. We see sometimes people coming in to help their family member plan, and they are trying to make the decisions for the family member. That is not permitted as long as the family member obviously has the capacity to do so, take selfish advantage of the situation by perhaps naming themselves as a primary beneficiary of that person's estate. Deal with the principal, the elder, in any way that benefits the fiduciary or prejudices the person in regards to that particular situation or other beneficiaries of the family. So let's move on to what fiduciaries and their responsibilities are. So who are fiduciaries? So fiduciaries are people who act as trustees under a living trust. And these are fiduciaries that are based upon a person's incapacity. So because we're talking about long-term care and caregiving, this is when this would apply. So when someone has been incapacitated, either mentally or physically, then that person that could be acting on their behalf could be a trustee under a living trust. It could also be an agent under a power of attorney. It could also be an agent under a healthcare power of attorney. So that the normal kind of power of attorney we think of is a financial power of attorney or property power of attorney, which controls physical assets. But healthcare powers of attorney, you also will act as an agent under that. And then last but not least, you could be a representative of the person under their Hipaa authorization. So let's talk about the very first one, the fiduciary under financial power of attorney. So what is the purpose of an agent in that role? Well, it's really to act for them while they're still alive, to basically act for them when they themselves cannot act upon the matters themselves, they become incapacitated. And so what does that mean? It means generally handling financial affairs such as paying bills that the person owes, executing contracts on their behalf, managing their investments, IRAs, 401ks, deciding upon different forms of long-term care, whether that be assisted living, maybe a daily caregiver in the home, or a residence in a facility, and collecting, let's say, rent or other benefits. So if your principal has rental income property, are other kinds of investments that have normal streams of income. The fiduciary would also be responsible for maintaining real property that they are either living in or owning, and doing any other thing that they would be able to normally do on their own behalf. Next thing we're going to talk about is what the types of financial powers of attorney. And there are three types. There's basically an immediate power of attorney, which we're going to focus on today. There is a springing power of attorney that we do not recommend. And then there's a hybrid. So let's go to the one that we generally recommend. The only kind that our firm generally recommends is an immediate power of attorney. What does that mean? Is that as soon as the principal signs it, as soon as the elder signs it, it is effective. So if you or I with full capacity decided to use a power of attorney, we could sign a power of attorney, hand it over to our spouse, other family member, friend, and let's say we're going to be out of the country for 6 months on a missionary trip, and we want to make sure that various things happen with our finances while we're gone. Once we sign that power of attorney, it is effective and it requires no further authorization on our behalf at that time. So no stipulations, no conditions apply to it. So this is something that can be used when someone's completely capacitated, but generally it's used at some point of incapacity. We don't really want the ones which we call springing, because they do have conditions, meaning that perhaps a doctor has to stipulate that or provide that a medical diagnosis that the person can no longer handle their own financial affairs. And generally, financial institutions are a little uneasy with those. They don't know if this really is the condition of the individual. Are they really incapacitated or not? Have these conditions actually been met? So for most financial institutions, only an immediate power of attorney is recommended, because most financial institutions do not want a springing power where they would have to determine whether conditions have actually been met before it's effective. In the case of real estate transactions, we're going to have those actually have to be recorded with the county in order to be effective. Now, the immediate kind of power of attorney should actually be presented to a financial institution as early as possible. We suggest our clients that upon executing one, that they provide them to their banks and other financial institutions, primarily by personally appearing with it at a bank and actually giving it to someone there. It's important for the bank to know that you did it while you were fully capacitated, you understood what power you were giving, and it makes it so much easier for when that agent comes to deal with that particular financial institution that you had previously, meaning the principal or the elder had previously given that to the financial institution. The other kind of power of attorney for medical decision making in our state is called the Advanced Healthcare Directive. And it's really a two-part document. One part of it provides the decision as to an agent who is being picked to make medical decisions when the elder or principal cannot. And then it also does give authority for end-of-life decisions, which we'll talk about. It's sometimes called a healthcare proxy in some states. Sometimes it's called a living will in some states, but in California, it is referred as to the Advanced Healthcare Directive. So as I mentioned, the Advanced Healthcare Directive is a two-part document. One, a part that relates to who can make decisions for me if I just, am unconscious even on a temporary basis, and the doctor needs to be authorized, for instance, for me to have a blood transfusion or to have a medical procedure or to receive certain medication. But it also applies to end-of-life choices. And this is an area that we really encourage our elders to make decisions regarding. These are areas that can have very, very devastating effects upon families when people do not make those decisions, as it relates to when someone is imminently facing death, and decisions have to be made as to whether or not end-of-life care will be given. In other words, whether someone will be placed on life support. So when an elder executes a power of attorney here in California, they have the option of declaring whether or not they want or do not want end-of-life care. As I said, normally relates to things such as being placed on a ventilator, perhaps being placed on dialysis, when there is no belief that the person will survive and that their death is imminent. We ask our clients, the elders, to make these decisions and take the responsibility off of their loved ones. And so they have a right to reject things such as feeding tubes and ventilators, or to accept all the decision of the elder. No right or wrong, but it should be personal. The other authorization that is provided for as far as part of the powers of attorney as one which is a federal authorization. And see if you can click the slide, Sandra, there we go, for the content to show up. So the Hipaa authorization is a Health Insurance Portability and Authorization Act. And what that actually applies to is the information that your medical providers collect from you during the time that you're actually under their care. All medical information is private and not to be disclosed to anyone, even your spouse, without a written release. So the Hipaa authorization is that written release where an individual designates who can receive confidential health information. It is extremely important nowadays. At the very beginning of the use of this document, many medical providers were not as strict upon having this as a means of being able to communicate with someone. But nowadays, it's because it is a source of litigation, and we can see that sometimes in the celebrity situations where they're in the hospital and their information leaks out. Often medical providers are sued for allowing that to happen. But it applies to, of course, all your health and medical files. So that if someone needed to take those files for, let's say, a second opinion related to your medical care, they would need the Hipaa authorization to obtain those files. And some medical providers are very strict with this, where they'll even apply to just speaking with your medical provider, just having the right to speak to your doctors and others about your medical condition. Those institutions who are extremely strict upon using this authorization are insurance companies. They will not, under any circumstance, even speak to someone who does not have a Hipaa authorization generally. And so what that means is often the caregiver is stuck in trying to perhaps find out whether or not an elder has coverage for certain kinds of care, or making decisions about that coverage without having a Hipaa authorization. When do power of attorneys not work? Well, they don't work when someone has passed away. So any kind of a power of attorney that a agent might have held becomes totally ineffective when someone passes away. So let's go to some practical tips. And this really comes from my and my firm's personal experience. And what the number one thing that I just really want to emphasize here is being attentive to the elders in your life. And whether that means you give them a call frequently or you show up, every couple of weeks at their doorstep. I actually prefer that if at all possible, because there's many things that can be determined by sight, by actually physically visiting with someone, that can't be done by just simply a call, like the condition of their housing, whether or not various people might be present in their lives. These are things that really are very important for us to know as our loved ones get older. So these are some common sense approaches that we advise our families to do. When you start to see that someone is starting to develop a physical or mental decline, one of the very first things we advise you to do is try to arrange for a medical exam. Believe it or not, they say that about 30% of what is originally designated as Alzheimer's or dementia actually can be corrected just by diet or medication. So that sometimes people are taking conflicting kinds of medication, sometimes they're not getting essential nutrients in their diet. And once those things are corrected, capacity returns. So that's one of the reasons we do want you to arrange for a medical exam as soon as possible. Often, once they've seen their regular medical provider, a neurologist visit is going to be necessary. And it's at that time when you start to see these changes in our loved ones, you really need to get familiar with their medical plan, the doctors they are seeing, the conditions that they have been diagnosed with, and any medicines or other kinds of supplements that they are being asked to take on a regular basis. Next slide. One of the areas that we really see there being a lack of participation by family members when someone has started to show this decline is an examination at the DMV. And so if the person is still driving an automobile, I think it's very important at that point in time for you to talk to them with a heartfelt manner about their own safety behind the wheel and the safety of others. And these kinds of examinations or checks are regularly done by the DMV. It was one of the first ways that I discovered that my mother was having issues when I got a call from her insurance company telling me that they were going to cancel her auto insurance. And I asked them why, and they said, because your mother doesn't have a valid driver's license. And once I spoke with my mother said, well, I went to the DMV, I took the test and I didn't pass it. And I said, well, Mom, that happens, let's study for the exam together and, you'll be able to pass it. And she just was adamant that she wasn't going to go down to the DMV and take another test. So I told her, I said, well, Mom, you're not going to be able to drive anymore. And I said, because you won't have a license and you won't have insurance. And what my mother's response to me regarding that was a very big indication that my mother had her mental capacity had changed. She said, well, a lot of other people do that, drive without insurance and a license. And my mother was not that kind of person. So I quickly detected that, her mental capacity, her cognition was changing. Ultimately, her personality was changing, and I needed to be more attentive. So spending quality time with your elders, being aware of what's happening in their lives, and when you detect something, to take aggressive kind of steps. This turned out to be one of the worst things that I could do when I took the car away from my mother. I had to hear about it almost every day. But if we care about them and just the general public on the street, then we need to do that. Also, at that time, I did hire a caregiver for my mom and started having someone come in and make sure she was eating well every day. And it's very important for you guys to understand the available services in your community. One that I do regularly work with is the Alzheimer's Association here in Los Angeles. They're all over the country, and they are very great at being able to provide you with resources that might be available in your community. Another thing to be thinking about when a person starts to show physical and mental decline is for you to actually arrange a meeting with an attorney regarding their estate planning documents. If they have them, it'd be a great time to review those documents with the person who prepared them. If they don't have them, it's the time to create documents. And as I said at the beginning of our presentation, this is what we're seeing so much now, of having younger family members bring their loved ones to us for the creation of these documents once they begin to understand that even if their parents or grandparents are capacitated, that it just hasn't been done. They just haven't prepared anything to protect themselves. Also, it's important that if you can, and this is where being secretive and not sharing information can often come in, to understand what's going on with banking and other financial transactions. That's one of the ways in which elder abuse is quickly discovered, is when we start seeing money moving from people's accounts and our elder doesn't recognize it, even though they might have authorized it at one point. Then we can detect whether maybe someone in the family or other people outside are financially abusing our elder. The other do's and don'ts for fiduciaries are when we start to notice the decline in cognitive abilities is if there is planning already in place to make sure that assets have been properly funded to that plan. So sometimes elders are under the belief that simply having executed, let's say, a will or a living trust is sufficient to make sure that those particular assets like real property or other accounts are actually controlled by that plan. But no, funding is important. You need to also check beneficiary designations. So accounts such as IRAs, 401ks, even life insurance, bank accounts are normally transferred at death to individuals through a beneficiary designation. Very important to make sure that those are not people who have already passed away or what I call undesirables, people who really shouldn't be benefiting from the elder's assets. Also important to look at the number of accounts our elder has. Often I find, when I sit down with some of my clients, that they have 10 bank accounts and, money is spread all over the place. And that consolidation of accounts are also a practical thing to do at that time. Also to know where things are, know where they keep the legal documents related to their planning, to help them organize those things in a way that can be quickly referred to when needed. And if we have an elder with over $12 million in assets, and in that case, a married couple, $24 million, that individual would be subject, or that individual's estate would be subject to the federal estate tax, which can be up to 40%, a very large hit. So we do want to make sure that we do determine what the value of our elders' assets is. This is especially important where people own many pieces of real property, and there's really no one who knows what the value of those properties are. So other do's and don'ts for fiduciaries are know what your elders want. Talk to them about it. How do they want their estate distributed at a time in the future? Who do they want to be in charge? This is really the basis for making sure that their plan currently represents their desires, or for the creation of a plan, knowing where their documents are. If you can click on the next line, thank you. Also, you would want to ensure that their documents are available 24/7. And we do have a way that we help our clients with that. We have all of our clients are subscribed by us to a service called DocuBank that actually allows a company to have access to the medical healthcare directives, the Hipaa authorizations, and any other documents they so please. So if our elder, let's say, was rushed to an emergency room and we needed to make a decision for them, that we would actually have the ability to simply contact this company and they would supply the medical directives to the medical providers at that time. When someone also starts to show decline, it's also a good time to talk to their attorney to figure out what might need to be changed. Powers of attorney particularly cannot be generally more than 3 years old. Most financial institutions will not allow them to be operative when they're older than 3 years. So even if someone has what looks like to be a robust estate plan. And then my last warning here is, please do not use unqualified people to counsel your elder. If you found that they had used a non-attorney, a paralegal, an insurance agent to do their planning, they need to have that planning revised by an attorney. Unfortunately, in the African American community, we have far more probate attorneys than we do have estate planning attorneys. And so many of our family members may have relied on unqualified individuals to do those plans. So here are some tips for sons, daughters, and fiduciaries. So if your elder is unable to find medical decisions, then you should use the Advanced Healthcare Directive. That Advanced Healthcare Directive will allow you to make medical decisions on their behalf. That also will provide for their end-of-life choices. The Hipaa authorization is also important to provide to the medical provider, because without that, technically, even with a power of attorney, there are limitations on what can be communicated to an individual who does not have a Hipaa release. And then, as I said, make sure these documents are up to date. The HIPAA requirements do change, so do the forms for the Advanced Healthcare Directive. Some providers like Kaiser and other medical providers have their own documents. And while we do recommend anyone to execute those, be mindful that those are really only something that apply to that particular medical provider. They always will need a general medical power of attorney, a general Advanced Healthcare Directive, because often our elders do not end up at, or do not begin the process, let's say, of a major medical need in their own medical provider. They may be rushed to a local emergency room, and so we need, or they may be on a cruise, or they may be on vacation, and we need to make sure that they have a medical healthcare power of attorney that applies to all providers. If an elder is unable to manage their legal or financial affairs because of a decline, then we do want to use the property power of attorney for these financial matters. As I said, we do not recommend any kind of springing or hybrid power of attorney, only an immediate one. And if you do use an immediate, then you would simply just have to present it to the financial institution. Again, our advice is to make sure that's been previously presented to them, because when they received it initially from the elder, they are less likely to object to the use of it later. If the elder is unable to manage their legal and financial affairs because of their mental impairment or physical impairment, then you really want to make sure that everything has been titled to them, to the trust. Can you click the slide? That would basically activate the trustee appointment. So if you are the trustee for your parent, you would be, or grandparent would be able to actually begin the authorization of handling their affairs. You would present those documents to the financial institutions, and probate would not be required. Can you click the slide, please? If anyone here does not have these things themselves, or are helping family members who do not have documents in place, and please feel free to contact our firm to discuss how we can make that a possibility. Next slide. So if the elder is deceased, then that's when the documents actually become operative. If the person has an attorney, then certainly do call that firm and set up a meeting with them. But if not, if for instance the client, your elder, used someone that's no longer practicing, or was not a qualified planner to begin with, then we certainly are available to speak with you about that at that time. You need to get the trust documents that are in the elder's home, and if you were actively involved with this person prior to their death, you should know where they are. You should perhaps have a copy available to yourself already. If you were actively involved as a caregiver, you should know where all of their bills are, and other kinds of things such as insurance policies and annuity contracts. These are parts of the things that as a caregiver you're doing while you're caring for your elder, as getting organized and making sure you are knowledgeable about these things. So if the elder is deceased and there is life insurance, annuities, IRAs, or retirement plans with pay on death, beneficiary designations, then you'll need assistance with this, because in many instances, you may not be the individual. So if you can click on the next paragraph, you may not be the individual who is entitled to information about this, but yet you would have some degree of responsibility in making sure that those people who do understand that they are beneficiaries. You'll definitely want to make sure that you're helping those individuals in the family who, let's say, are beneficiaries, to get the required forms and things that are necessary from these companies in order for the payout and for them to be processed. However, if your elder is well planned for, has actually prepared a trust and all of the accessory documents, there will be no probate necessary for the transfer of these particular assets. They will generally go by beneficiary designation. In some cases, the estate might actually be named as a beneficiary. We do advise this with a lot of life insurance policies, that rather than individual beneficiaries, that the estate be actually named, because there's a need for funds at a time someone passes away. And often a life insurance policy is the best way to have those funds immediately available. So other do's and don'ts for fiduciaries, whether you decide to consult with our firm or a firm that perhaps your elder previously picked, before you actually start changing title to assets, it's always good to speak with the attorney prior to doing that, or the financial advisor, and sometimes the CPA, because there are many results that can be obtained by doing it the correct way, good results, and then unfortunately bad results when we don't know the impact of changing, let's say, the title on a particular asset. We need to be careful, particularly with retirement, with accounts, IRAs, 401ks, because with the passage of the Secure Act a couple of years ago, there was basic changes in the way people could actually receive benefits from those particular kinds of accounts. And so prior to making any change in them or claiming on them, it's always good for there to be some advice given by attorney, CPA, or financial advisor. Other do's and don'ts. When we have married couples and the first person in that couple passes away, then we have a survivor, and that survivor usually is the primary beneficiary of retirement accounts, life insurance policies, so forth and so on. And so after they have actually, let's say, inherited those assets, if those assets remain as often are retirement accounts, the new beneficiaries need to be provided for those accounts. So even at the very first death of a married couple, there are very significant things that need to be done. Another thing that needs to be done are replacement of the power of attorney for both medical and property or financial. Generally, married couples pick each other to be their first power of attorney agent. So husband picks wife, wife picks husband. And of course, when they're no longer able to serve in that regard because of death, then we need to revise those powers of attorney. Again, financial institutions do not like to see old power of attorneys where the first agent has passed away and then a secondary is now the person who is stepping up. What it means to them is that there was no attention given to this document while the person was alive, by virtue of the fact that that first agent had already passed away. So maybe the elder didn't want this secondary power of attorney agent to really actually be in that position anymore. It's these kind of concerns that financial institutions have that make them reluctant to act on powers of attorney. I'm just going to cover some very, very basic estate planning concepts today. We have a wonderful webinar that you can either ask for on demand, or you can attend where we will have a question and answer session. And those who do that are entitled to have a free consultation with our firm. So let's just go quickly through the types of estate plans. There are estate plans where wills are the only major document used for passing assets. And then that in our state are only recommended really trust with powers of attorney. Reasons why in our state we do not recommend wills is because of the fact it's a very, very costly process in the state of California. We do not have an inheritance tax in our state, which many states do, but our probate process makes up for it and more. A will does say how your assets are supposed to be distributed after your death, but it has no way of protecting you during your life. So a will doesn't designate who actually would be in charge of being your power of attorney agent for incapacity or disability. And often with a will only, again, which only comes into effect at death, we see conservatorships that are necessary to control the life of an elder. I know everyone's, probably familiar with the Britney Spears case, But commonly, if you were go down to the Los Angeles Superior Court and sit in a probate courtroom, you would find that at least 50% of the people in that courtroom are African Americans. Well, we nowhere make up 50% of the population of Los Angeles County or own of 50% of the assets, but because of our lack of preparation, we're overly represented down at the probate court. So both conservatorships and probates are held in those departments of the LA Superior Court, and they are both very expensive processes for a family to go through. Whereas with the trust, you are actually providing for incapacity. You are determining in that document who will be in charge of your affairs when you become incapacitated. The trust itself has those provisions along with powers of attorney. Therefore, there's in most cases no need to involve a court when someone perhaps loses capacity through dementia, because the trust itself already determines who will be in control. And then there is no probate with a trust. So in many states, there's not a big difference between having a will or a trust because of the processes of their court systems, but there is a tremendous amount of difference in the state of California. So having a trust and powers of attorney during life definitely maintains flexibility, because only at a time when the elder would need the use of those documents, such as having a decline in cognitive ability, would those documents actually be operative. A trust is like, having a guard dog sit by your side until someone comes up to attack you. The guard dog can be petted, the guard dog can be trained, but when emergencies occur and the need for that to jump up, that our dog to take control, they can. In the same way with the trust. The trust doesn't interfere in your planning, in your decision making. It doesn't affect your mortgage. It doesn't have any effect upon those assets, except when you become incapacitated or pass away. And then the trust controls the actual distribution. And it allows our elders to make very important designations as to not only who they want to be in a position of caring for them, but also how they want to benefit their family. Who they may want to leave real property to versus financial accounts, or maybe they need to control the distribution of an individual life because they have special needs or other things. There are minors that particular kind of asset wouldn't be distributed right away to an individual in either one of those cases. And then upon someone's passing, one of the great things about trust that people don't recognize often is that people can leave things in the trust of their elders. And that's really how rich people stay rich people, is that most affluent Americans do not allow their family members to actually have control of all of their assets at their death. They control those assets over generations in many cases, from having any effect by, let's say, a beneficiary's divorce or a beneficiary's debts, or just failure to plan or failure to handle mishandling of affairs. So we can actually protect inheritance for beneficiaries over generations with the use of a trust. So when someone passes away, this is what can be expected. If all they had was a will, or they had no planning at all, which is unfortunately what Sandra pointed out at the beginning of the presentation, is just how few people actually have planning. We would say only about 30% of the African Americans have done any form of planning at all. But if you had used a will, then you are guaranteeing your family will go through probate. Nothing or a will always requires probate. A trust does not require probate. It is a trust administration process, which only involves the decision-making of the trustee, that person that the elder picked to make those decisions and to handle the distribution of that process. Nobody else's authority is required in a trust administration process. There are many reasons why we should avoid probate. It's expensive, it's time consuming, can take between 9 months, 2 years, and what I call a productive probate, but in many cases, it's years. We've seen probates where it lasted 5 to 10 years for a number of reasons. And then it's open to the public. When a probate is filed, all of your assets are open to the public. The documents that are needed to actually have that process ensue require that everything be disclosed to the public. We see a lot of gentrification happening in our community now as a result of that, the information out there regarding the sale of real property can be through an auction basis, and that many of our properties are being lost to that. I mean, I don't have a problem with someone of a different ethnicity moving next door to me, becoming a neighbor in our community. It's just that we should make that decision. African Americans should make that decision as to whether or not that's what they want, or do they want to keep that property in the family. And we'll talk about that a little bit more as we go along. Also, multiple probates can occur. So if your family member has even a timeshare outside of the state of California, we've had to probate timeshares in places like Vegas and Orlando or what have you. That only the probate in California will control. California real estate will not control any real estate outside. So often our families are required to do multiples. Will your estate be subject to Medi-Cal recovery? Well, this is kind of a detailed discussion, but just know that the majority of people on Medi-Cal are not necessarily, particularly as long-term care, people without assets. They were just people who failed to plan for long-term care and don't have $10,000 to $12,000 a month to be able to fund that kind of care. So Medi-Cal can be applied for even if you have a home in the state of California. We won't go into detail about assets, but if someone just gets in-home care, someone who, a lady that comes in for 4 or 5 hours a day, let's say, to care for an elder, every expense that is incurred in that process will be documented and accounted for by the state of California. And at the end of that individual's life, there is a federal obligation on the state to recover all funds that were used for that person's long-term care benefit. And so what the reality is, next slide, is that California has recovered over $1 billion. And I think by now, this is a little old, probably $2 or $3 billion from Medi-Cal recipients' assets through real property, bank retirement accounts. That money has to be returned back to the state of California. I had one family that came in with a $900,000 lien against the estate that was incurred by an elder. Next slide. However, in the state of California now, we're one of the few states that allow this. If that elder has a living trust and the assets are in that living trust, there is no Medi-Cal recovery. So that same family that perhaps the elder incurred a $900,000 debt over many years of, let's say, long-term care and hospitalization, they will not be able to recover. So a will allow the state of California to recover, but not a living trust. So next slide. You must have a trust to avoid Medi-Cal recovery. And many people say, oh, I'll never be on Medi-Cal, but we just don't know. And so we need to be prepared. Next slide. This is an area where we are very, very dynamic, and we are very, very proactive in our community because we do believe that Black wealth matters. And next slide. Believe it or not, the 3 most affluent Black neighborhoods in America are located in Los Angeles County. View Park, Baldwin Hills, and Ladera Heights are the 3 most affluent Black neighborhoods in all of America. After that, it goes into Maryland and only one place in New York. These are Black neighborhoods, not where necessarily Black people live, but majority ownership of these neighborhoods. These are the 3 most affluent. Right now, and I checked these numbers before I came, and I'm going to update them with you. $935,000 is the average home value in Los Angeles County, not 680, 935,000, while the national average for of a home value is only 374,000. So you can see the great disparity between what we have a possibility of being owners of versus what other people in the United States do. There has been a 250% rise in the median sales price for homes in South Los Angeles since 2010. while only 30% of African Americans have a will or a trust. In my neighborhood here in Inglewood, between 2015 and 2022, there was a 125% increase in the values of homes in Inglewood, and I'm seeing it right before my eyes. There's almost no property in Inglewood and in many parts of South LA that will sell for under $1 million. So those of us who are residents and owners in Los Angeles County and in these neighborhoods have to understand how much there is to protect. And often our elders, we think that their property's worth close to what they paid for it many years ago, and are not really aware of that. While we make up 13% of the US population, we only maintain 2.6% of the national wealth. So that really illustrates the effect of discrimination, the effect of the long history of slavery, and challenges that we have faced over the years that we've not recovered from. But for our families who have something to maintain, even if it's a bank account or a life insurance policy, we want to make sure that those assets are protected in a way that helps us build generational wealth. Next slide. So the whole goal is to build wealth, and I'm glad to see that you had a financial advisor early in your series talking about that during your lifetime. And then next, the key is to closing the generational wealth gap is making sure that that wealth goes down efficiently through generations. And many of our clients are not just planning for their children, they're planning for their grandchildren, great-grandchildren. And then last, on this slide, white heirs in the United States receive 10 times more of an inheritance than Black heirs too. So we do have a lot to protect, whether it's here in Los Angeles County or it's in California, as relates to home ownership. And we need to realize how rare that is for us to have this kind of wealth by just making a smart decision to purchase a piece of real estate, and how much it could be worth to our families, how much it could advance our families when we handle it correctly. Okay, so how do we handle our matters? Well, basically, we call it our continuation of care. And we just not only prepare plans for our family, but we prepare everything or offer everything we think that may be necessary. So if you can click on the slides, free phone calls during our client's lifetime, free trust review meetings with our clients, sometimes just answering questions, but often actual changes need to be made. We also provide free meetings with the trustee or power of attorney agent after someone's actually had incapacity, so that we can make sure things are in trust, things are being handled correctly, answers and questions are being given to that person. Next slide. We have a wonderful website. This is where, if you have a piece of paper, you might want to jot this down, but our website is www.collinslawgroup.com. On our website, you're going to see multiple 50+ articles, reports. We have all of our educational events. We previously did a lot of live seminars. Now everything is a webinar. We have a webinar next Saturday. We have them all through this year. And as I mentioned before, we have on-demand webinars that you can do. If you are sincerely interested in preparing your elder and their assets, then we would invite you to go to one of those webinars. We'd invite you to bring them to the webinar with you. And once you've completed that attendance, then you will be offered a free consultation with one of our attorneys in our office. And at that time, you can ask your personal questions. We can give you a personal recommendation, and hopefully you choose to become a member of our Collins Law Group family. We're very experienced in trust administration services, so if there's trust in place, we could perhaps already advise you. And both in large estates and small estates, we're happy to work with everyone. So please feel free to share this with other friends, family members. We actually receive the majority of our legal services or actually go to people who are referred to us by our clients and others, and love to provide those services to you and your family. The thing that our clients receive many other benefits, but we do provide digital copies, next slide, of everything to our clients. Those copies are on a flash drive. We do a what we call we do a personalized video for all of our clients that gives them great detail about what they've done and how they are immediately their plan. And last slide, next slide, the famous quote by Pablo Picasso that only put off until tomorrow what you are willing to die having left undone. And I think that's something that is a great manner of thinking about this. If it doesn't matter to you or matter to your loved one, then maybe you can afford that. But most of us want to benefit from our assets to the day we close our eyes, and we want the right person to be there managing them and protecting us during that period of time. And then we want to leave something behind to those that we care about, to institutions and worthwhile causes that we'd like to see survive us. So the next slide, I think we're missing one in between, really has a list. You can go back one slide and see if it's there. Okay, go forward again, and let's see if it's perhaps there at the very end. We do have as I mentioned, free webinars that are available to all of you. And so if you'd like to find out about those webinars, go to our website, look under webinars, and you can register right there on our website for them. So I want to thank everybody. First of all, I want to thank the UCI Black alumni for inviting me today. It's very much my pleasure to share this information with those who share a common experience with me, which is having enjoyed the benefit of attending University of California at Irvine and receiving a degree from there in comparative culture, which no longer exists. But I'm so happy to have met those of you new to this particular program, and all of those individuals who are responsible for organizing this. I appreciate so much your interest in this and hope to be a resource to you over time. Thank you so much.
Sorry about that. I was having some audio issues, so I wasn't able to respond. I think that there were a couple of slides were missing, so I apologize for that. But we will share those resources in the chat with folks, so that way they can have access to it.
Thank you.
So, so with that said, we will open it up to Q&A. So please, folks, if you see down towards the menu of the Zoom, if you haven't already, please place your questions there. We will try to answer as many of them as we can. And so while people are doing that, I just want to say, Caprice, I am just blown away by the information that you shared here. I think it's just, as someone said, it is so timely. And I've learned so much within this, just in this hour, and so many things that I appreciate you sharing in such an actionable way and relatively easy to understand. Just given the fact that this is a topic that a lot of people don't want to talk about. A lot of people think of the topic of death or pending death as taboo, do not want to engage with it at all. But in order to really protect our assets and help our family members and think about the future generation, we have to talk about this. And so that leads me to my first question to you. And just thinking about how, in the research that I was doing, that there's sort of this like boomerang effect, where in the past it was the boomerang effect where you had the college kids, they graduate, they try and get their first job, or, you know, they go to graduate school and it didn't quite work out, so they come back home, right? But what's happening now, especially with the pandemic, there's this boomerang effect where you have kids coming back home because now they're being caregivers. Now they have to take care of their parents, or the parents are moving in with their children, right? So you see a lot of that happening. And what's happening is that now we're being forced to have these tough conversations. And a lot of times the parents do not want to engage in these conversations with the kids because they're like, hey, I'm the parent. I know more than you. I've lived a long life, so don't come talking to me about my medication and my finances and all of that. And especially if you're the baby of the family, oh, please don't talk to me about that. So I'm wondering if you could speak to that, maybe offer some insights or advice on like, how can the children address or approach those conversations, and how can the parents be receptive and open to having that conversation, even though they really don't want to?
Well, first of all, I just want to emphasize when we talk about the amount of wealth that we, that we actually have in the United States in comparison to our population, we have to be real. Okay, we've got to be real. We have very little to protect in comparison, meaning that we need to be very aggressive and proactive with it. So I think, as caregivers or potential caregivers and as the elders, we really don't have the option to, ignore this. That's just the way I feel about it. We got to be serious if we want to extend something to those that come behind us. But I think in the case of a potential caregiver, what's good to do is to perhaps have this conversation with the webinar. Sit down. We make it very I want to say funny, but we make it something that's enjoyable to watch. And I think people can relate to it. And I think that's something we're just providing information because there are so many myths out here. I saw some of them in the chat, oh, well, I thought you only had to go to probate if you had this or that. No, there's no limitation. Or you have to have more than that. Nope, people can go to probate for a $5,000 check. If a check came in the mail to your family member after they died, okay, for $5,000, there would be no way that you could get the authorization for that check to be, let's say, deposited into a beneficiary's account without a probate proceeding. And so it's unrealistic to think that these things don't apply to us. So I think being educated is really the very, very first step. And what I think either both by, the elder and the potential trustee or personal representative, once you see what the facts are, I think you're much more likely to act on it. The other thing is that I see a lot of people who've been through probate. A lot of families were, they probated their mother's will or didn't have a will, just their estate. And they've actually experienced it, of years of going to court and the cost and all that. And unfortunately, that is a motivator for many of our, family members to actually get something done. So I think being educated is the very, very first thing that I would think of. Maybe talking about what happened with grandma's estate. You remember that, Mom? Remember all the hassle, or when grandma was in the hospital and we knew she didn't want to be on life support, how we didn't really have authority to remove it. Do you remember how, my uncle came down there and did this or that? Just kind of recount to them what happens when we don't plan, some of the tragedies that may have already been experienced or you've seen in your own experience, with friends or others, wow, her mom passed away and they had 3 pieces of property. And at the end of the day, they only got $10,000. How does that happen? Okay. Failure to plan, not having things in order, maybe having a big Medi-Cal lien that needed to be paid off or someone ripping off the family. So using real life experiences, educating through the webinar that we offer and any other source of information you choose to use, I think it's the very first step for both sides, both the younger generation and the older generation, to kind of come to Jesus moment, like if we don't do this, this is what's going to happen. Okay. So I would just suggest that there's tragedies and challenges and the things that have happened almost every family that if we think about it, we can recount.
I agree.
Sandra,
I agree. Oh, sorry. Go ahead, John.
I was just going to add, I had a chance I was referred to Caprice by someone at UCI Irvine, and I've had a chance to attend their webinar. I would tell everyone in this room and go tell someone else, that webinar is phenomenal. To put is an understatement. It is, and I'm not saying it because she's on the line, but it is a phenomenal webinar. I referred people there. The information she gave, as you can see by the chats, by the comments in the chat room, has been absolutely awesome. I saw someone said they lived it. The advice you're getting today, you'd be paying an arm and a leg for. Go to her webinar. I'm telling you, we are lucky to have you. And thank you, Caprice, for being here and all that you've done. But their firm is, what she's saying doesn't even begin to touch the surface of what they actually do. So thank you.
Well, I think what we do is we try to be comforting to people over, over the process. And so we're not a one and done. We don't just do do the documents and then bye, nice to know you. We're here when, when somebody takes a slip and fall, when somebody gets a bad diagnosis, when somebody does well, they got grandchildren they didn't have before, and now they want to revise things so that they can benefit multiple generations. We want to be here for all of that, the good and the bad, And we just want to avoid those mistakes. And it's our honor to help our community preserve. Wealth is not just about money. It's about life lessons. It's about so much more than that. And so it's our goal to have that pass from one generation to another with love.
I appreciate you sharing those words because just as I mentioned earlier, just this topic in a lot of ways is taboo and scary for some folks. So just to hear you say those words and then have that confirmed by John's experience by attending your webinar and just hearing how warm and inviting and supportive you and your team are at your law firm is just really nice to hear, and knowing that we can come to you with our questions and trying to figure out how we can best care for our families and just think about our future. So what I'm going to do now is go through some of the questions that we have received through our Q&A so far. So first question we have here is, do you recommend a trust if an elder has property and you are an only child?
Yes, because if that property is in the name of your elder, it will require probate. And the great thing about having a living trust is that, for instance, when my mother passed away, she left me 2 pieces of real estate. And for one of those pieces of real estate, it is still in her trust. So a trust provides protection to the beneficiary. So I can personally be sued, and many of us are in a professional capacity where that's a possibility, but it will never touch the property that my mother left me. It is still in her trust. Now, as a trustee, I manage it. I collected rents. I use them appropriately. But if something were to happen to me tomorrow because of my mother's trust, my children will get the property that my mother left behind and will go down the bloodline. My husband is not in the picture as far as that particular trust is concerned. So creation of a trust provides asset protection to the beneficiary. So whether I divorced, had a lawsuit, owed taxes, any of those kinds of challenges, will never trust the property that my mother left in her trust.
I appreciate you emphasizing the differences between wills and trusts, because I'll be honest, I was thinking, hey, if we have a will, we're okay. Especially if we think that it's detailed and it has everything in there in terms of how we want to be cared for, how we want our assets managed, until we ultimately pass. It should be more than enough. And I just appreciate you sharing how it's limited in a lot of ways compared to what trust can do.
Let me just say, wills have nothing to do about how your assets are managed during your lifetime. It is only operative upon death. That's it. That's when it applies. And it only says, who gets what. But, generally wills are not something that's going to stay open for generations, okay? They're meant to really be operative at death, distribute everything. So if a grandmother wants to make sure that her grandchild gets money for a college education, it would not be through a will, unless that person was given to, that person was received the money right away, okay? Versus it being conditioned. Most of my clients, they want it conditioned upon things like you maintain a certain grade point average and so forth, as relates to that support for the college education. So again, remember, wills only work when you die, and anything that might happen to you previously prior to your death, the will has no effect upon at all.
Got it. All right, kids, keep your grades up and stay nice to your elders, all right? So you can be in their good graces. Moving on to the next question. Can you speak to the challenges in inheriting an IRA?
Well, there's been a change. The Secure Act, which was passed a couple of years ago during this pandemic period, basically changed the way that those particular accounts could be inherited. It used to be pretty much the same, no matter what kind of beneficiary. But now only a spouse can inherit those accounts and then use them over their lifetime. And what they used to call that was the stretch IRA. You might have heard that phrase, where someone could basically use an account over their lifetimes, have it really annuitized for use. However, now under the Secure Act, only a spouse has that right, and any other beneficiary, such as children, grandchildren, or any other person, has to take the entire amount out of the IRA within 10 years of the person's death. And what really the government was promoting is taxation. They want those funds to be taxed very quickly versus what was the previous allowance of a stretch IRA. So it means that basically, leaving an IRA and thinking that my beneficiary will be able to, maybe retire with this IRA, which a lot of what my parents thought, oh, when I die, then I'm going to leave this money and then my children can use it as their retirement fund, doesn't exist anymore. It must all come out within 10 years of the elder's death.
That's really good to know. Thanks for that. Next question. Will having a long-term care policy be beneficial for our loved ones to help take care of them?
Definitely, definitely. The state of California is very strict upon who can sell long-term care insurance in our state. Not any company can come in. We have one of the most protective insurance commissioners, departments in the nation. So only very high quality companies can sell long-term care insurance. There's lots of ways to provide that. You can do it with a one-time payment, like almost in a form of an annuity. You can actually take annuities you presently have that, maybe just paying you an RMD and put it in a long-term care policy. There's what we call standalone long-term care, is where you pay for it, like you pay for life insurance. When you stop paying, you no longer have the coverage. So there's lots of ways to buy long-term care, and just know that our state requires that a long-term care policy must apply to every form of long-term care, meaning in-home care, assisted living, dementia care, nursing home, hospice care must apply to every form of care, which means that no matter what your loved one needs, they'll get some care. How much, they'll get is based on what they buy. It's just like a life insurance policy. You can buy $50,000 or you can buy $5 million. It's up to you as to how much long-term care you want to buy. But it's basically based on per day. So in other words, I buy $200 a day worth of long-term care, means that I effectively bought $6,000 worth of insurance per month. Our recommendation now is no less than $300 a day, which is about $9,000 a month, because the cost of care is so high. And then once you say, okay, I want $300 a day, you say, how many years do you want that to apply? And normally, people are going between, let's say, 4 to 6 years, saying, I think that would cover me. So it's an analysis that if any of you are interested in, I'd be very happy to sit down and talk to you about it. Some of us need to buy maybe a little more than others. In my case, my mother died from dementia, and she lived for a good 10 years with dementia. So I wanted a longer policy when I bought my long-term care, because, hopefully I won't go down that road, but I do have the propensity based on my parents. And that is something that's very prominent in our community, because we have 3 times more long-term care incidents that we all may have much more likelihood. And all of us who are women have a much greater likelihood of having Alzheimer's than men.
Thank you. Next question. Do you think life insurance is a great way to leave wealth for our heirs?
I do. I encourage people to get life insurance. I encourage you to get it young, when you're very healthy and you have lots of options, and where it's primarily cheap, okay? Because that, hey, I'll tell you, there's nothing better to come to someone after someone's death than a check that comes in the mail, okay, versus, oh, I got 5 pieces of real property that I got to manage and all that other stuff. So I do believe that in the context of all the things that you can leave, a life insurance policy is a good thing. There are some ways of using life insurance, particularly if you have a taxable estate, to help pay the taxes that might be involved. But yeah, I think particularly if you are someone who is supporting others. So that's where I think, we normally buy life insurance is when we're young parents and we realize, I could get hit by a bus and this 2-year-old, is completely dependent on me. I better get my act together and get some life insurance. So I don't encourage someone who's 65 and has no minor children and, husband is as well off as they are, really to buy to buy life insurance. But I think most of us buy it when we're young for the protection of our children, and you buy a quality product at that point and keep it up. I think it's worth having.
For sure. Next question. Is it possible to specify in a revocable trust what happens to assets of beneficiaries when they die? in parentheses, they have already benefited from the assets of the trust.
Definitely. You can decide if a person gets full control of the asset, like what we call a direct distribution. So, if you had $500,000 in the bank, you had 5 kids and all 5 of them got $100,000 and you gave it to them as soon as you died, then basically, it's up to them to protect it. But a lot of trusts provide that there is what we call staging. In other words, okay, the first year they'll get 5% of this amount, or they get 10%, and every year thereafter they'll get X dollars or X percentage. And if they die before that full fund is basically taken out, then the trust itself provides who gets it. In other words, does it go down the family line, the bloodline, to their children and grandchildren, or perhaps it goes to another family member, or it goes to a charity in place of that. So there's a lot of creativity that it's done. It can be done in trust that it doesn't even apply in the case of a will.
Okay.
Remember what
Next
I said?
question.
This is how rich people stay rich, people, okay, by not letting all of their wealth just be received unilaterally at the time of their death. They're planning for wealth to be into the family over generations.
Mhm. Next question. If you are a joint owner of a parent's bank account and that parent has passed, is that account part of the estate, probate, or does that account belong to the child?
That account will belong to the child. If you are an owner of the account, then the death of your loved one would make you the total owner of that account, and all you really would need to submit to the bank is a copy of their death certificate.
Okay. Is there any limits on what can be in a trust? Like, can you put businesses under a trust?
Definitely. And that's one of the reasons people do trust often, is because of the fact that they have multiple streams of income, multiple assets, and they want it all controlled so that for the benefit of their family members. And so that's another reason why entrepreneurs and other business owners really need to get serious about planning, because they need to have a control over that asset, even if they just have a slip and fall, or an accident where all of a sudden, let's say if you employ people, who's going to write the checks to make sure my employees stay with my business while I'm recuperating in a rehab situation. So the more that you're involved in life, the more that you have at stake, the more you need to do that. You need to involve a one central plan. The trust is like a quarterback. It has, the control over everything that could potentially be wealth to the family. Businesses, obviously real property, accounts, intellectual property, all of those things.
Right, right. So next question. How much net worth should an individual have before setting up their own trust?
Okay, so net worth is not an issue. First of all, if you're over 18 years of age, everyone who's listening needs to have powers of attorney. So everyone here, any one of us are more likely to become disabled than we are to die. Everyone listening today. And in that case, you need someone to be in control of your assets for you, okay, or for your child's sake until you're in a position to actually regain control. After that, if you have a child, then you do absolutely need to have a will. A will does provide for guardianship of children. But if you have any asset to protect that child, even if it's just a $100,000 insurance policy, you need a trust, because you want to control that. You want that policy to be made payable to trust. You may even want to designate the trust as a beneficiary of retirement assets, which we don't normally do, but might be the right way to protect that child. So if you have any obligation to someone, and I even have had this happen when the child feels that when they're caring for their parent, they want their assets, like if they have a good insurance policy with their employer or what have you, to be devoted to the care of their parent. But they know their parent can't really control it, that, there needs to be someone else. So having a trust doesn't really depend upon your net worth. It really depends on assets and who you feel you owe an obligation to.
For sure. All right, so everyone, we're down to the last couple of questions here in the Q&A. If you have any final questions, please feel free to add them to the Q&A as we begin to wrap up. All right. So next question. Do you know the limit or cap for death taxes?
Death taxes can be state imposed. There is no inheritance tax in the state of California, been abolished many years ago. And only a tax on an estates occur at the federal level. And right now, if you have an estate individually of approximately $12 million or in excess of $12 million, you will be subject to the federal estate tax. And right now that is the high of that tax is 40%. So let's say you had a $14 million estate when you die, you'll be exempted of $12 million, okay? Not applied to, the tax would not be applied to that first $12 million, but that last $2 million of value, 40% would be taxed, which would be approximately $800,000 that would have to be paid. So it's a bite, it's a big bite. And those who, have that kind of estate need to be very, very protective of it by making sure that you have planning. But with proper planning, we can avoid the tax altogether so that there is no tax of that $14 million estate.
Yeah. And I think we'll end it there because the key word that we've been hearing throughout this presentation and even in previous presentations, preparation is key. So it's all about preparation, folks. And so if we prepare when we do have those challenges come up or even have those surprises, we are in a better situation. We're in a better state to be able to handle that. And so with that said, thank you again so much to Caprice for your time today and just dropping all these gems. I took a lot of notes and I will be watching this recording again and I will share it out with folks because this information is so important. And so I just can't thank you enough. And I know everyone else on this call feels the same way. And so with that said, I will turn it back over to my colleagues.
Well, let me just say one thing. Our telephone number is 310-677-9787. And feel free to use it and to go to our website, collegelawgroup.com. Thank you so much for having me today.
And before we, excuse me, and before we go into our final closing, I know we're going to give away 3 $25 gift cards to Amazon, and Arnicia is going to give that away. So please, if you're around, don't hang up yet because you can't win if you're not going to be in there. And last but not least, I want to echo what Sandra said, and we've seen throughout all the comments, Caprice, absolutely wonderful presentation and invaluable information. I thank you kindly, ma'am, and I will call you, we'll touch base for certain. And so I can personally talk to you, but this has just been absolutely phenomenal and I appreciate it. And actually, if you can stick around for a few minutes, as soon as we do this, I think the 4 of us will go into a quick chat for about 5 minutes. And so with that, I'm going to turn it over to Arnicia, and Arnicia, take it away. So
again, we would like to say thank you so much for participating today in this valuable information that Caprice shared. I feel like we have a superstar on our team now that is here for us with a resource of wealth and knowledge to help us, just do better. Like she said, rich people, this is how they stay rich people, right? So I got that. I caught that. And so we definitely want to do that. And so we normally have people answer questions, but because of the topic and how severe and critical it is for the betterment of our community, we're just going to give away the 3 gift cards this time. So as we spin the wheel, I'm going to click spin and a name will come up. And if you are here, so Roderick Seamster, are you here? If you're here, I need you to put your name and your email in the chat right now.
and while Rod is doing that, this is another UCI alum undergraduate that is also a Harvard graduate, Dr. Roderick Steamster. So we have talent abound, and please stay tuned for our future webinars. Thank you, Rod, for attending.
Thank you so much. And We'll remove him and we'll do the next giveaway. Abigail. If you could put your name and your email in the chat, please, Abigail. If you're here. Going once. Going twice. Okay, we're going to remove Abigail. Some people had to leave, so we totally understand. Janelle Butler. Janelle, if you could put your name and email in the chat, that would be great. And I can see that Janelle is still here, so. And last but not least, Janelle, we need you to put your name and your email in the chat, please. Joni Forge. Oh, no, I'm sorry. I'm sorry, it rolled over. So, Corrine Srupnian. Corrine Srupnian. I hope I'm saying that correctly. Are you still here? Okay, go ahead, Corrine, and put your name and your email in the chat. And we thank you so much. At this time, we'll turn it back over and let John have the closing remarks.
Again, we want to say thank you to everyone for attending. Our next webinar is coming in the month of May, and it's going to be more phenomenal information. It's going to be about staying healthy, Black folks' diseases. We're looking at a nutritionist, exercise expert. So again, please share with everyone you can. Excuse me. To attend, please pass this information on. Today's webinar is being recorded. It should come out to you within about a week or so, and we will make sure everybody gets it. If not, reach out to the UCI Black Alumni Chapter. Go to Collins Law Firm, get that information, folks, and everyone have a wonderful weekend. Thank you. We appreciate your support and be well. Take care, everyone.